Hi, I'm Anish Dayal. I'm a lawyer who's been practicing for the last 20 years in the Supreme Court of India, the Delhi High Court and other forums. A very special part of my work is the media, entertainment and sports practice. We have advised a number of clients in relation to their creative rights, including musicians, authors, painters. Artists have been ignored in terms of the legal protection that the artists get, particularly artists at the lower levels and medium levels who often don't have resources to reach out. So the main protection which the law provides us is under the Copyright Act, the Indian Copyright Act, and essentially the work of an artist would come under the purview of the Copyright Act. For example, if it's a painting, or if it's an author of a work, or if it's an engraving or an installation, anything which is represented on a piece of paper or some medium is copyrightable. Copyright itself is not compulsorily registrable, which is a very important issue which people sometimes miss. Once you create a work, an original work with your own blood and sweat, that is itself copyrighted in your favor, in the sense that you own the copyright for that without having to register it. Registration is only an additional process which is optional, it is provided for, and will only give you extra evidentiary value of the fact that you are the owner of that copyright. For example, if you are taking substantial portions of somebody else's work or somebody else's text, then you ought to make sure that you have the permission of that person to use that. For example, if you are writing a book or some kind of a coffee table book, let us say, which has certain text and it has certain photographs, then you must make sure the text is your own, but the photographs have been taken from somewhere else. You have to make sure that you have taken the permission or the license from the copyright owner of those photographs to use them in your text. So, intellectual property right is a generic term which is used for a few things. For example, copyright is what we mentioned. Then there are patents, which are really inventions of a physical form. Could be like a device or an industrial device. And then there are trademarks, which is really like a logo or a brand name that you use, which a company or a person can use. So intellectual property rights is a generic word which covers these three aspects, three principal aspects. For an artist or any creator of a work, copyright becomes the most important of the lot. Patents doesn't really come into the picture. While I must say that as legal advisors, we have often had people sitting across the table and saying, I have an idea, can I patent this? Because patent is so loosely used, the word is very loosely used. But patent is only for inventions. The other thing I would like to add here is that a lot of people today come up with a query that I have an idea, can I protect it in a manner? So let me make it very clear that an idea cannot be protected per se unless it is represented in some form or fashion. So you might have an idea of a game show, for example, on television. You might think that this is the way a game show would work, but that idea in itself is not protectable. You discuss it with somebody else can use it as well or come up with the same idea. But yes, if you put that game show format on paper with the proper description of how the game show would go, that written representation will be copyrightable, but not the idea in itself. So not all issues really go before the court. So we have dealt with a number of artists and a number of entities in the media side and media entertainment side. There are issues which have come relating to artists or musicians not getting their due payments from the people who have commissioned them to do their work, which is usually a recovery issue. but it is also based upon the contractual understanding which the musician, the performer, or the artist has had with that particular company. The other sort of cases which have come is about copying of works. For example, there have been authors of books. For example, there was a student's tutorial sort of guidebook written by a very popular author, which was substantially copied by an online agency and put up on the website. When that was discovered, we sent a notice on behalf of that author to the website, which decided to pull out portions of it. However, what we had done was to take printouts and evidence and stored it while it was still on the website, which gave us enough evidence for us to actually sue the person in court. Thanks to that action that was taken by the author, the matter got settled and the person who was copying this text had taken it off completely and closed down the website. Besides this, there have been particular issues relating to artists where works which have been given by an artist to a gallery, let's say, have not been returned because there was an ambiguous understanding which was not crystallized on paper, and the artist was fretting and fuming about the fact that the gallery hasn't responded back, the works have not come back, the works are extremely expensive, whose risk is it going to be? You have to make a bit of an effort to make yourselves aware of what your rights are. If you are a bit aware, you should take steps while you are transacting with somebody, let us say a gallery or a publisher, in order to protect your rights at the right time. So one thing is to make sure that you're dealing with somebody you preferably know or familiar with. That person has a certain reputation in the market so that you're not taken for granted or not cheated. Then making sure that you are clarifying all aspects of your transaction with that particular person. You have to make sure that whatever is being discussed is being put in writing. What happens normally is that if somebody has a better negotiating power over you as the artist, then you and says that we really don't want to put this into an agreement, but it's a trust and faith issue, it's what has been discussed, then what is advised is that an email recording that meeting or that arrangement can be sent by the artist, which often gives us a very important recording of the fact that this was indeed the arrangement. That helps later in sorting out issues and disputes. The company or the publisher or the entity finds it difficult to renege out of that commitment. So agreements don't necessarily have to be really complex. We as lawyers tend to sort of make it complex or make it sound complex, but even a small one-pager agreement, a 1.5-pager, 2-pager agreements, simply saying that I am the owner of these works, I'm giving it to you for this purpose, this is the amount of money that you're expected to give to me. As simple as that, like even a written letter would suffice to give you legal protection. I'm extremely glad that this project has been undertaken by Artists at Work, and I think they're doing tremendous work in terms of increasing awareness, and I hope it goes a long way in empowerment of artists on the legal protection of their rights.